All right, good afternoon, everyone. Welcome back to our Isolation Economy webinar series with SGTech. So our new friends who are joining us for the first time today, thank you so much to our friends from Singapore Business Federation and Singapore Management University for jointly co-organizing this series of webinar for us. So today's topic we want to talk about is the legal consideration to adopt e-signature in the isolation economy. Basically, are electronic and digital signature good enough since we are all still confined at home and should be staying home to help save life? With me here today, I'm very lucky to have Yue Ping from Bird & Bird, a SGTech member company who will be giving us the sharing about this topic itself. But before that, we always want to give you guys a safe harbor statement. Especially today, all this information provided is only meant for education and learning purposes. I always ask you guys to help us by seeking your own independent legal and accounting advice before making any business decision. We try our best to maintain all the content as accurately as possible, but in the event that we fall short, please always email us and let us know. All right. Now, my name is Ivan. I'm your host for today. Thank you so much for once again tuning in so regularly with us. I'm a cooperative counselor with SGTech. So what is SGTech? Now, we are the premier trade association representing more than 900 companies in the tech industry in Singapore. We are doing all of this series, as a way for us to reach out to SME who are not in tech, to think about all the implications about digitalization, technology, and how the COVID-19 situation has really led us to change our entire business model altogether. If you were to go to isolation.sg, you will be able to see a toolbox and a webinar of all our past events. Now, the toolbox basically is a curation of services and items that might be useful for a lot of our SME friends here. Today, we are very lucky to have Adobe, NetTrust, and Sleep to share with you their e-signature solution as well for today's sharing session. On top of that, I want to promote something. We're going to have a big webinar next week. As you know, circuit breaker will end on 1st June. We are entering a phased approach to end the circuit breaker itself. For those of you, SGTech, as always, will be doing a special webinar on 28 May on Thursday, 12:30 noon. It'll be about budget number 4 and the start of the new normal in the isolation economy, where we'll go through what the different phases means for businesses in Singapore and any new budgetary announcement that Minister Heng Swee Keat will share. We believe this will be a very big and informative session. So if you're interested, we will send out the link. But if you really want to sign up now, you can scan the QR code here and you'll be able to sign up for this special webinar, and you'll be co-hosted by myself as always. All right. So with that, as well today, we'll be giving you guys an industry survey after the sharing session is over. Now, over the course of a few webinars, more and more people are doing. Thank you so much. But for those of you who are not doing the industry survey, can I appeal you guys to help us make this webinar series better? SGTech, we're doing this as a public good service. If you help us do this webinar, help us do this survey, it will really help us direct and focus our attention on what really the SME community in Singapore really needs. All right, I'll remind again you guys later. So for those of you new to this, as always, we'll give out the slides of this webinar, especially from Bird & Bird in a short run. They'll be available on the SGTech website and on isolation.sg. The recording of this session will also be available, but it will take us about 2-3 hours to process it. And most importantly, any point of time you have a question for Yue Ping here from Bird & Bird about e-signature, please click on the Q&A function in Zoom and type in your question for us. We are not able to monitor the chat session, so if it's a question, please once again help us answer in the Q&A and we'll address them collectively after the sharing session. All right, so once again, without further ado, let me welcome Yue Ping from Bird & Bird. Yue Ping, over to you.
Hi, Ivan. Hi, everyone. Let me share my screen first.
No problem.
Okay, so can you see my screen now?
Perfect, thank you so much. All good.
Okay, great. So my name is Yue Ping, and it's a pleasure to be here with you today to talk about legal considerations regarding e-signature. So before I delve into the presentation, let me introduce myself. I am a lawyer from Bird & Bird ATMD, and I advise clients, many of them are from tech companies, on IP issues, regulatory issues such as data protection, such as consumer protection laws. And then I also help clients draft commercial contracts, for example, NDA and IP licensing agreements. So prior to becoming a lawyer, I was trained as a chemical engineer, and I worked for a pharmaceutical company for about 5 years as a project leader in drug development for diabetes and autoimmune disease. So with that background, I think I'm able to anticipate some of the challenges that my clients face, especially when my clients are doing the R&D phase. And I'm able to provide advice that's commercially practical. So with that, let me go directly into the presentation. So e-signatures. So in view of everyone working from home now, e-signatures have become a very hot topic. So if you were to type in electronic signatures on Google, you'll have many, many hits. And one of the most common questions asked is, can electronic signatures be used? And I think a lot of times people would say, but of course, everyone is doing it. However, if you delve deeper, the answer is it really depends, as with a lot of things in life and in law. So what I hope to share with you today in the next 30 minutes are these 3 things. So first, what is an electronic signature? Second, is it legally binding? Is it enforceable in court? And lastly, what are the factors you have to consider when using one? So for this presentation, the third item is really the bulk of, is really the meat, because at that time, I'll be giving you a practical checklist as for what you can ask yourself, when using e-signatures. Okay, so what is an electronic signature? So like a wet ink signature, it's a record of someone's intention and consent. And when I say wet ink signature, what I mean is that I take a pen and then I have a piece of paper and I sign my name. So that's wet ink signature. An electronic signature is an electronic signature that records a person's intention. So for example, pasting a digitized image of a manuscript signature, using your finger and signing it on an iPad, and ticking a checkbox or clicking I accept on an online form. So now, are they legally valid? The short answer is yes. E-signatures are generally valid in Singapore, and e-signatures are regulated under Electronic Transactions Act, short form ETA, under Section 8. So Section 8 says, where a rule of law requires a signature, the requirement is satisfied in relation to an electronic record if the method used identifies a person, indicates a person's intention, and is reliable. So again, they're generally valid provided that identifies a person, indicates the person's intention, and is reliable. So what happens in the unfortunate event that the agreement with the e-signatures are being disputed and you have to go to court? Is it enforceable in court? So this is also regulated under the ETA under Section 19 sub 2. And it essentially says that in a proceeding involving a secure electronic signature, it shall be presumed, unless evidence to contrary, that the secure electronic signature is the signature of the person to whom it correlates and was affixed by that person with the intention of signing or proving the electronic record. So now you might ask, what exactly is a presumption? And it's a term that we often use in law. So simply it means the starting point. Provided that you have a secure electronic signature, in court, the judges will presume that it is authentic and it has integrity. The other side can still offer evidence to prove otherwise, but that's the starting point. So I think especially for high value contract, it's important to think, is the electronic signature that you're using considered as secure electronic signature under the ETA, where there's a presumption that the signature is authentic and has integrity? So the logical question is, what makes something a secure electronic signature? So in the Act, they define the term as a signature where there's a security procedure involved that can verify an electronic signature was, at the time that it was made, unique to you, identifies you, created under your own sole control, and is linked to an electronic record. And let me give you an example of what would not be considered as secure electronic signature. So for example, if I were to sign my name on a piece of paper and then I scan it and then I cut my signature and I paste it on an agreement, that would not be considered as a secure electronic signature under the ETA because it wasn't done via a security measure or a security procedure. And certainly there's no electronic record. So there are e-signature software providers out there that are able to help you with that. And I think later on in this session, there'll be a review of some of those services. So now let me go into the bulk of my presentation, which is the checklist. So in this checklist, there are 6 questions that you should ask yourself when using e-signatures. And these are important questions to ask yourself, especially to protect your business. So the first question is, what is the type of document that you're dealing with? Not all documents actually allow for e-signatures. There are some exceptions. Are there any company restrictions? In your company constitution, is there any restrictions about using e-signatures? How about the other company that you're contracting with? Is there an overseas element? What is the governing law of the contract? Is the governing law Singapore or is the governing law something else, maybe Indonesia or New York? If it's New York and Indonesia, then what is the position of e-signatures in those countries? Number 4, does the person actually have authority to sign the document? If the person doesn't have authority, then the agreement is actually not binding. Number 5, is there a risk of fraud? And lastly, have you stored all the relevant records related to e-signatures in the event that there is a dispute? So let's go to the first one. What is the type of document that you're dealing with? If you recall, I mentioned earlier that the ETA, under ETA, it is generally accepted. The e-signatures have the same effect as a wet ink signature, but there's a caveat. So under the ETA, there's a list of excluded matters where e-signatures are not permitted. And then the next slide, I'm gonna share with you this list, which can look very complicated. And I won't go into details here. So here is the list of excluded matters where e-signatures cannot be used. And not all of them will be relevant to you in a commercial context. For example, the first one, the creation and execution of a will, that would not be relevant to you. But things such as power of attorney, where you give certain power to your attorney to act on your behalf. And if the company owns or wants to buy land, then any contract in this case involving land would need to have a wet ink signature. It's important to note that this list may change, and that's because last year, the IMDA came out with a consultation paper on the ETA to offer some suggestions on how the ETA can be improved. And one of the proposals is that all existing excluded matters for business-related transactions are proposed to be removed. And one of the reasons for this is to be in line with how other countries have handled electronic signatures. For example, in New Brunswick, Canada, there is no list of excluded matters. But for now, the list hasn't changed, so it's important for you to still refer to this list. Now, let's say that, so now what are some examples of things that are not on this excluded list? So they are your HR documents, commercial agreements, consumer agreements, software license agreements, NDAs. So those can be signed with using e-signatures. Now, let's say that you've gone through the list and your document is not on that list of excluded matters. What you should do is to go a step further and ask yourself, are there any formality requirements that the document must have a wet ink signature? For example, if you're submitting documents to the government, does the government have any requirements that it has to be signed using a wet ink signature? And the other thing to note is something called deeds. So maybe you have come across this. So deeds is a form of contract, but it doesn't have consideration. And in order for it to be valid, certain formalities have to be followed. For example, there has to be 2 signatures, and it should be done by way of paper using wet ink signature. There is some dispute, there is some consideration that perhaps deeds can be done electronically, but the position in Singapore is not very clear. And I would suggest that if your company has to enter into a deed, it's really best to execute it using wet ink signature. So that's the first question. What is the type of document that you're dealing with? The second question to ask is, are there any company restrictions? So ask yourself, does your company have any restrictions on the use of e-signatures in your constitution? And constitution essentially means the documents that govern how the company should operate. How about the other contracting party? Have you checked with them? So what do you look out for? So go through your constitution and see if there's any provisions, any clauses that prohibits the use of e-signature. If it does, then you want to amend it. And that's the event that your company decides to use e-signatures. If it doesn't, if it's silent, then you can go ahead and use it. And what some parties do in a contract is that they'll have an additional clause saying that the parties agree to sign the agreements by way of electronic signatures, just for the avoidance of doubt. You should also ask the other contracting party if they have any restrictions and keep a record of it in the event of a dispute. So that's the second question. Does the company have any restrictions? So the third question is there an overseas element? And I think this is very relevant because nowadays a lot of tech companies are entering into contracts with overseas entities where the contract governing law may not necessarily be Singapore. So governing law, it's a clause in your contract that you'll have that essentially says if the contract were to be disputed, what is the law to interpret this agreement? So, and you can't assume that all the other countries are the same as Singapore. They may have a different position. So it's important to check with your lawyer, does the governing law in that country allow for e-signatures? And ask also, would there be any enforceability issues if you were to go to court with it? So let me give you an example. In Indonesia, the law generally allows e-signatures to be used. However, if the agreement were to be disputed in the Indonesian court, many of the courts will only accept agreements using wet ink signature. So it's really good to ask yourself, what is the governing law and what is the law in that country? Do not assume that the other country's law is the same as that in Singapore. So the fourth question, does the person have authority to sign this agreement? And in company law, the term authority has special meaning, and it is only the company who can give someone authority to sign agreements. So ask yourself, does the person that you're dealing with have actual authority conferred by that company to sign the agreement? And ask for evidence. And here I have a little picture of a bag. So I think a lot of you have bought expensive purchases before, maybe an expensive bag or an expensive watch. And undoubtedly, you'll know that there are counterfeits out there. There are bags and watches that look so good, but in fact, it's fake. And I think most of you in that situation would go a step further and ask for evidence, ask for a certificate from the company to prove that the bag or the watch is the real thing. And I would suggest that you do the same thing. And it's not enough for the person that you're dealing with to simply say, I have authority. Similarly, it's not enough for the bag to just say, Louis Vuitton. What you need is evidence from the company that the company has given that person authority to sign on the company's behalf. If the person has authority, in this case we call it actual authority, the agreement is binding, so that's good. But what happens afterwards? You find out actually the person did not have authority to bind the company. what happens to their agreement? So generally, the agreement would not be binding unless there was apparent authority or ratification. So these two are legal terms. And whether there's apparent authority, whether the company ratified, for example, after the agreement, they still paid up, is really fact sensitive. And there are so many litigation cases on those issues. So it's really best to just rely on actual authority. Now, the fifth question is there a risk of fraud? And I think this point is especially relevant now, given that we are in the isolation economy and we're not able to meet the person face to face. And I was reading up on cybersecurity issues, and I realized that cybersecurity issues have been on the rise, especially with COVID-19. And the WHO, World Health Organization, actually has experienced a drastic increase in the number of cyber attacks on its network. And hackers were not only able to impersonate WHO's identity, but they have also sent out email scams to the public. Another news article talked about this cybersecurity company experiencing a surge in calls for help to resolve cybersecurity attacks, which is now a common occurrence in cybersecurity companies. So this is a real issue that you have to consider. And what do you look out for? So first you want to ask yourself, if you're already using e-signatures, is there a possibility that someone can steal my e-signature? And then ask yourself, how about the party that you're contracting with? Does the e-signature really belong to that person? And you definitely want to ask yourself this question if you haven't interacted, if you haven't negotiated with that person before. Are there any suspicious factors that make you question the identity of this person? And I'm going to give you an example, a real case that happened in Australia. So this is a case, Williams Group Australia versus Crocker, that happened in 2016, and it went before the Court of Appeal in New South Wales. So Williams Group Australia is a company that they provide building materials, and Crocker is a person. So Mr. Crocker was the director of a company called IDH. So what happened in this case is that Williams Group wanted to enforce a personal guarantee against Mr. Crocker. Pursuant to a trade agreement, a credit agreement, and personal deed of guarantee that where e-signatures were used, Williams Group provided building materials to IDH. Now, what is a deed of guarantee? And it's actually not uncommon. So essentially, it's an agreement saying that if the company is not able to pay, the directors will pay themselves. So by May 2013, IDH had owed Williams Group almost $1 million. So it's definitely not an insignificant amount. And not surprisingly, IDH went into liquidation. And the logical choice for Williams was to sue the directors under the deed of guarantee. So in this company, IDH, there were 3 directors. And 2 of the directors, William was able to enforce that deed of guarantee. But the last director, Mr. Crocker, he argued that his e-signature was placed on the guarantee by an unknown person without authority. So essentially his argument was, my e-signature got stolen. I didn't sign it, and I should not be bound by this personal guarantee. Williams Group tried to argue otherwise and tried to argue that there was apparent authority, there was ratification, those 2 terms that I mentioned that are highly fact sensitive. And in the judgment, there are pages and pages of discussion about whether there was apparent authority and ratification. At the end of the day, the court rejected all the arguments from Williams and found that Mr. Crocker was not bound by the personal guarantee. So now you might be thinking, how did Mr. Crocker's e-signature get stolen in the first place? So what happened in this company called IDH is that there were 3 directors who worked from different offices. And the managing director, the MD, decided, okay, let's sign up for an e-service, an e-signature service, HelloFax, that will help the company get the agreements in order and help the directors sign the agreements in an efficient way. So the MD gave Mr. Crocker his username and password. Unfortunately, Mr. Crocker never changed his password. So what this meant was that anyone who had login details would be able to affix Mr. Crocker's e-signature on the documents. And unfortunately, this is what happened. So a lesson to be learned from this case is that change your password. And here's a list of practical things that you can do to help ensure that your e-signature is safe, that it doesn't get stolen. So what you can do is to step up the security measures to prevent malicious threats, control the number of people who have access to the documents, to the transactions. Not everyone in your company needs to have access to that agreement. Update your password on a regular basis. I just want to pause here to share a little bit that I was talking to my niece who is doing online learning. She's 5, and I asked her, how do you sign up for this e-platform? How do you log in? And then she said, oh, password. And I asked her, can you give me your password? And she said, no. So I think kids know not to give someone else your password. But sometimes, every day is because things are very busy, and the person who has authority to sign, for example, the director, gives his password to someone else, maybe his secretary, to sign documents on his behalf. And that I really don't recommend it. I don't recommend giving your password to anyone else because you don't know where the password may land. Even though you might trust your secretary, for example, you don't know that maybe someone else may be able to have your password. And it also raises questions when you're the one who with authority and you're not the one applying your signature. It raises questions on the validity of the signature, the validity of their agreement. So now let me continue with the list. So disable any outdated computer components that could be used as an access point for hackers, use secure e-signature platforms, and even consider creating an e-signature policy. So in some of the bigger organizations, e-signature policies are very common. So the e-signature policy details what documents can be signed by e-signatures, what documents that should not be used with e-signatures, what platform should be used, what's the recording process after the agreement has been signed. So these are some things that you should consider doing to protect your own e-signature. Now, how about the other party, the party that you're contracting with? How do you make sure that the person signing is really the person? And given that we're all working from home, we're not able to meet the person in person, but it's important to meet him virtually, have a Zoom call, ask questions, see if there's anything suspicious, do your due diligence, especially if you haven't interacted with the person before. And you might even want to call the company and see if they're aware of this negotiation. And if the company says, no, I'm not aware of this negotiation, then alarm bells should ring. So moving to the sixth point in the checklist list, which is actually the last point, have you stored all the relevant records related to e-signatures? And I think a lot of people think that getting the agreement signed, that's the last step, but that's not the case. The last step is really proper storage. And you want to ask yourself, have you kept a copy of the e-signature, e-sign agreement, as well as email records relating to e-signature? And this can be really important if the agreement is ever disputed in court. So here's the checklist again, and I shared a lot of material. So let me just review what you want to consider when applying this checklist. So first, ask yourself, what is the type of document that you're dealing with? Is it something under the excluded matter? Are there any other requirements that a wet ink signature must be applied? Ask yourself, does your company have any restrictions on the use of e-signatures? How about the other company? Is there an overseas element? What is the governing law of the contract? If it's not Singapore, then you want to go a step further and ask your lawyer, what's the position of e-signatures in that country? How about any issues in terms of enforceability? Does the person have authority to sign the document? Is there a risk of fraud? Is the person who's signing really the person who he claims to be? And lastly, have you stored all the relevant records related to e-signatures? So that's a checklist. And so this is the slide that I share with you at the very beginning of my presentation. Can e-signatures be used? And I hope by this time I have drilled in all of you that the answer is not so simple, that it really depends, and you should ask yourself these questions in the checklist before you use e-signature. And I'll just leave, this is my last slide that I'll just want to leave this with you. So especially when there's a lot at stake, when the contract is high value, where there may be issues that it will be litigated in court, really adopt a cautious approach. So with that, I will hand it back to Ivan, who will moderate the Q&A sessions.
Hey, thank you so much, Yeping.
Thank
As
you.
well, Yeping information is available here. I think that was really useful. I didn't realize there were so many factors to do with e-signature. Just happy
Yeah.
signing along. And for all SME friends here, most importantly, please do not share password. I think that is just basic hygiene. Okay, Yeping, we have a few questions.
Sure.
Let's take a group of them first. The most important one that I think a lot of people are asking is, so the signature standards are different across jurisdiction, including Southeast Asia. Is there any website we can go to find the standards, say if I'm operating across to Indonesia and say Vietnam, or do I have to consult a lawyer for that?
So the best is to consult a lawyer because there are nuances in the law, especially if you're dealing with high value contract, as I mentioned, where there's a lot at stake. But at the same time, there are a lot of articles out there that are written by law firms about the e-signature position in different countries. So that may be a good first step if if finance is tight and you're not able to consult a lawyer. But again, the best is really to consult a lawyer. Especially for high stake contracts.
Okay, if it's legal in nature and the cross borders, that would be something to look out for.
Yeah, that's right.
All right. Okay. Lydia asks, what are the essential elements to be included in an e-signature policy?
So the question is, what are the essential elements to include in an e-signature policy?
For SME to adopt, yes.
Sure. I think the first thing is be clear as to what documents can be e-signed and what documents cannot be e-signed. And be clear as to who has authority to sign, who has the authority to e-sign. Because I think what happens in some organization is that it's not very clear who has authority, and people just signs it even though they're not supposed to. So to summarize, the first is be clear as to what documents your company wants e-signatures and what documents you don't want e-signatures. And second, be clear as to who can actually e-sign.
Got it. So, go ahead.
And I guess another point to add is the security measures, and as in addition to what is the record keeping. And I would emphasize record keeping because I've noticed that a lot of companies, that's an area that can be improved in. But record keeping is really important because you don't know what might happen down the road. So it's important to keep all the records related to e-signatures.
Got it. Thank you so much. Some of you, we have a few questions in the group, such as, would there be recommended companies? Yes, we have Adobe, TrustNet, and on top of that, NetTrust. We have Adobe, NetTrust, and Sleek with us. These are three companies that provide e-signature services that you guys can hear about in a very short while after we answer all the Q&A. So do continue staying. This is not the end of the webinar. Just continue staying, and they'll be able to share with you their solution. Now, on top of that, thank you so much, Ping, because I have uploaded her slides that she's sharing today on the isolation.sg website. I pasted a link. You guys will be able to access it. Now, back to some additional questions. So this is something that even myself is curious. I have signed so many e-signature using a lot of this software. Why do I have to do like my signature in a squiggly line and on top of that, type in my name as well, like Ivan Cheng, after is it over? Does it matter? Like, can I just put a little cross or draw a little smiley face and write Ivan Cheng? Does it work?
So it's a good question. So signature, it can be, I mean, it doesn't mean that you have to, the signature can be anything. You can use your thumbprint, you can, and there's some fancy signatures where it's
like a smiley face is fine.
Yeah, and one of the reasons why a lot of times you'll see a little box saying type out your name is because you can't figure out who that person is who signed it, because the signature is, you can't decipher. So that's why a lot of times you have that little box, to write out your signature so that you can identify who actually signed it. And I think what you want to consider is, what is the document that you're signing? Maybe if it's a document in your personal capacity, then perhaps, that electronic signature that you use doesn't have to be so secure. But if there's a lot at stake, then you want to think about using one of the secure e-signature platforms where it clearly indicates that you signed it at this time in the event, or that person signed it at that time in the event of any dispute.
Okay, so leading on this question, on Shenton's question, so let's say I have an image file of my signature and I drag and drop into a PDF document and I export it out again as PDF. Is that considered e-signature?
It is an electronic signature, but the question that I want to ask is, that you want to ask yourself, is it a secure electronic signature under the ETA? And it'll be good to just go back to the slide and at your own time to see, does it meet all those requirements? Is there an electronic record? Is it done by way of a security procedure, which, as you described, I don't think so. So if that's not the case, then actually there's no presumption in court that it's authentic and that has integrity.
Okay, got it. So it needs to be, there is at least, depending on the severity of the document as well.
Yeah, you want to, just take a thoughtful approach, I would say.
Okay, got it. There's a lot of questions. Just let me quickly use. Once again, those of you who are asking us to recommend e-signature system, we have a few vendors here. We don't take a position on any of them. I think they're all great. Just stay in and you'll be able to listen in on them as well later. Let's talk about having a witness on e-signature. Does it make sense? Do you need, as I sign, do I need my mom along there to show that, yes, does it make sense?
Yeah, it's and that is a really good question. E-witnessing. So first, not all documents have to be witnessed, but what happens is that sometimes companies or people, they're a bit cautious and they think, oh, it's best to have it witnessed. But in fact, for the agreement to be valid, it doesn't have to be witnessed. So I think you want to first ask yourself, given now, like everyone's working from home, practically witnessing is very difficult. So ask yourself, does the agreement need to be witnessed? And the other thing that you want to ask yourself is, if it has to be witnessed, are there any other alternatives? So I mentioned earlier about deeds, right? And deeds have to be signed by certain people in order to be valid. And under the company's law in Singapore, it can be signed by 2 directors or by a director and a witness. So in this event, there's an alternative. So, go with the alternative. And I guess the last point I want to add is that in other countries, this topic is making headlines. So in Australia, for example, my colleague, the Bird and Bird office in Australia, actually wrote an article about a new legislation that happened in New South Wales, I believe, in Australia, about witnessing, e-witnessing. What are the requirements regarding e-witnessing? But in Singapore, we don't have that regulation yet. So I think the short answer is, go back and ask yourself, does the document really need to be witnessed?
Got it. Okay, sorry, I think I'm having feedback. Okay, we just want to answer one or two more questions. Let's talk about company stamp. For some reason, Singapore still have a lot of documents that requires the circle company stamps, even though we have moved away from that. Are we able to make the company stamp into e-signature or wet-in version?
Company seal. I think so. The
Not
question
seal
is,
though, company stamp though. The company seal is under the, yeah. It's just a lot of times documents wants you to stamp the company name. It's a little circle chop, I guess.
yeah. So I think similar to how I answered the earlier question, you want to ask yourself, does the agreement, whatever you're signing, does it really require that company stamp? And if it does, then you want to ask the place where you're submitting the document, does that organization or does the government have any requirements that required that it has to be, physically stamped? So that's something that you want to ask yourself.
Got it. And I think final questions, because I know you have to run off. For those of you who we did not answer a question, not to worry. We are able to, you can email info@SGTech and we can see whether we can forward some of the questions over. And Yeping, sorry, I think you might get flooded by a lot of the SME asking you a lot of clarification.
It's a very interesting topic, so.
It is, right?
Yeah.
I think biggest question that I have is like some of the SME member ask, okay, so let's say we're really scared of e-signature. Should we video ourselves signing the e-signature? Does it help? And is it presentable in court? That will be the last question for today. Yes, should I film myself signing it?
I mean, there's no one stopping you, but as to how effective it is, it hasn't been tested in court. But I just wanted to, say that a lot of times, actually witnessing is not needed. As long as the agreement was signed, then that's valid. So it's a step that you don't necessarily have to take. There's nothing stopping you, but it hasn't been tested whether the court would put weight on it.
Got it. So it still depends, and it's still a chaos because we have not really tested it. There's no precedence in court, basically.
Yeah, that's right.
Thank you so much, Yeping. I really appreciate you coming. I think it's a phenomenal sharing. We have so many engaging questions. There are more than 45 questions that I wasn't able to reach to. So for those of you who I have not been able to address your question, we are sorry due to time and because of Yeping as well. But once again, thank you so much, Yeping. We really appreciate it. Thank you.
Thanks, Ivan. Thank you, everyone.
Thank you.
Bye.
Take care. Stay safe. Bye.
Thank you.
For the rest of our friends here, we are now going to transition on to sharing from 3 solutions. Just before I pass my time over, there is an industry webinar survey. Please help us do it. If you have some time now, just take out your phone, scan this, do it now. Please help us do this. All right. Now, some of you guys have been regular audience and you want something fun, a little promotion here. In case you are very bored on Sunday and you have nothing to do, you're always welcome to attend baking class with me. This Sunday, we are baking macarons. All right, this is something fun outside of SGTech for you guys if you want some enjoyment and some entertainment. All right, so thank you so much, ladies and gentlemen, for this part. We are not done. Please do not leave. I'm now